I'm Karen Cross, CEO of the Greater Kingston Chamber of Commerce. We are once again pleased to be partnering with KPMG to bring you our next Chamber Live, Hybrid Workforce Legal Considerations. After a year and a half of remote working has challenged many to rethink traditional work models. With so many employers transitioning to hybrid workplace models, we thought it important to first discuss the new and emerging key legal issues. We are delighted to welcome KPMG to share their insights on balancing legal obligations and effective people management. I'd also like to thank KPMG for sponsoring today's episode and for their continued support of this series. Now I'll turn it over to Jessica to say a few words.
Thank you, Karen. So we have an exciting presentation planned for you today, but before we get started, I would also like to thank our title sponsor, KPMG. KPMG has been serving businesses in Kingston and Eastern Ontario for over 100 years. With 40 professionals locally, KPMG's office in Kingston operates as one unit to bring new ideas and opportunities to clients in the private company and public sector space, in audit and accounting, risk management, and business advisory and tax. KPMG is managed locally here in Kingston, which allows them to make client service decisions quickly. This local strength is complemented by their ability to access KPMG professionals from across Canada and worldwide as needed. Kindly note that today's session is being recorded and will be available on our YouTube channel later this afternoon. We have allotted time at the end for a Q&A session, but we encourage you to enter your questions in the chat as we go along. Now, I would like to introduce your speaker for today. He is a management side lawyer whose practice focuses on employment and labor law. He advises employers on a wide range of issues, including employment standards, labor relations, policy and contracts, wrongful dismissal claims, health and safety, and human rights. He represents and advocates for clients in litigation matters before courts, arbitrators, and other administrative tribunals. Prior to joining KPMG Law, he practiced in the labor and employment group of the national Canadian firm. Please welcome employment and labor lawyer of KPMG, Maciej Lipinski.
Thanks very much, Jessica and Karen. Much appreciated. It was a pleasure meeting you this morning, pleasure meeting the group, and look forward to the opportunity to present to everyone today. So first off, I'm going to try and share my screen so the all precarious technical issues. Let's see if we can get through it. Does everyone see the first slide, which should say hybrid workforce legal considerations there?
Yes,
I see some nods. So, okay, perfect, great. So I'll just move on to that as well and see if we can, there we go. So second slide. So I'll get right into it. So start with a bit of context. I think it comes as no surprise to anyone. Oh, I see. Bear with me here. The slides have taken on a life of their own. So go back. Let's start with a bit of context. I think it comes as no surprise to anyone that the past year and a bit have significantly changed worker expectations around the workplace. Here's one example of that, where a KPMG survey found that over 70% of employees surveyed both, number one, expect location flexibility, and number two, state that they can be just as effective working remotely. But as we see on this slide, that's not the whole story, as the trade-off is that employees still want to connect, collaborate, and socialize with their coworkers. Okay, so moving on to the next slide. So that has many employers looking into making changes that combine some form of remote work with some form of work at a physical shared workplace. And we call this combined model the hybrid model. So effectively putting a hybrid model into place effectively means considering multiple building blocks that are illustrated here, from human buy-in from employees to our organizational structures, what's our organization work like, to thinking about regulatory compliance, what digital tools and equipment we offer, and what are our physical facilities like, as illustrated here on this slide, along with some key points. So this is an important one that if you're looking through the recording, maybe pause here, note some of these. And we emphasize here in this diagram to look at the workplace as an ecosystem. So when we're thinking about making changes, we not only want to think about the change we intend to make, say to where workers are located and going to be doing their work, but how each change impacts on the other factors and the other aspects of the ecosystem. And then to break it down in terms of employment, there's two main relationship structures, what we call relationship structures, to pay attention to when it comes to making the employment relationship work and when it comes to mitigating disputes, which can be particularly important during times of change. All right, so on the one hand, we have the formal structures illustrated here, which is things that lawyers traditionally get called in about. Things like your written policies, your contracts, where you spell out the rules and the obligations, and they could be legally enforced as such. But as people who work in managing employees know, there are also informal structures at play. And this is where we get into the concept of, on the other hand, things like the psychological contract. So what is the psychological contract in the workplace? So this informal structure, the psychological contract, comes down to whether an employer and employee are meeting each other's unwritten expectations in areas like fairness, reasonableness, good faith. So imagine an employee in your workplace who technically follows the rules, but takes liberties with management's time, has a disrespectful attitude, but they're following the rules, technically speaking. Imagine an employer, on the other hand, and the employer regularly changes policies on employees on short notice. Both of these may be fine as far as the formal structures are concerned. Technically, there's no breach of a written policy or a contract, let's say, in either example. But these actions do likely breach basic expectations on both sides of fairness, reasonableness, and good faith. When those expectations are breached, other issues can arise and the relationship can deteriorate. You may have issues of employees taking a lax attitude at the workplace, and disciplinary issues arise from that. You may have issues with employees taking a lax attitude to maintaining security, and cybersecurity is a big issue these days. And on the other hand, you may have issues with an employer and management maybe being a little too keen to terminate an employee too soon, and you have issues arising from that. So it's important to keep in mind when we're making change, when we're approaching the workplace and trying to mitigate issues, including legal issues, that we think about both of these structures as being important to managing that change. We want to be looking at our formal structures, which your lawyer can advise you on, but you want to keep in mind and you want to keep your lawyer engaged in thinking about the informal structures as well. What are your relationships like? What are your employees like? What are their expectations like? So these are the legal issues that come in many forms when managing transitions in the workplace. So in the employment context, we see litigation stemming especially from terminations, employees claiming to have experienced harassment and discrimination, bringing a human rights claim, or change in the workplace that we didn't intend to be a termination results in what we call a constructive dismissal. We'll talk about that. We have regulatory investigations being a potential issue, so employees can make complaints to a Ministry of Labor on a health and safety issue, employment standards issue, and we can have resulting from that an investigation. They can sometimes become quite intrusive, where regulators will come to our workplace and ask questions and potentially impose orders. We have things like class actions and unionization, where employees can get together and take an action against an employer together. Employees can get together and try to unionize. And as we've seen more and more recently, employees can get together, have a class action seeking damages, and actually use that as leverage to unionize as well and try to do both at the same time. And then more towards the informal end, the potential for security breaches arises as well, where we have sort of, again, that informal sort of psychological contract aspect potentially leading to real legal issues. And this is one example of that. So now, being mindful of the ecosystem that we've talked about, the ways that things can go wrong, how do we anticipate that and ensure that we steer our organization that makes our hybrid model, number one, sustainable, number two, effective, and number three, competitive? So when we think about sustainability, we want to think about mitigating that risk that we talked about. When we think about effective, we want to think about optimizing the workplace performance, performance of our individual employees. And when we think about competitive, we want to think about what are our competitors doing a better job, and also differentiating ourselves for purposes including recruitment and holding on to our existing employees. So first thing we're going to talk about is managing compliance, more on the legal issues end. And this is particularly important when it comes to that being sustainable piece. Right? We want a sustainable hybrid workplace, so we want a workplace that's compliant with some important legal considerations that we're going to get into. Okay, so this slide deals with what we call the spectrum of flexibility. So you have at the bottom a traditional workplace model, working from the office every day. Moving up through that model, though, we see different options in terms of involving some form of hybrid remote working, whether that's working from home part of the time, near the office, getting further from the office, but staying within the country of employment, all the way up to the top where we have a work from anywhere type model. Now, the important thing to keep in mind when it comes to the spectrum of flexibility, and we'll get into the details of how the laws differ across provinces and between nations. But for example, if you have employees working out of province, and that may be the type of flexibility we want to offer, we also have to consider that employment standards differ between provinces. So there's a difference between Ontario, BC, PEI, et cetera, in terms of the thresholds for when we have to pay overtime, how much overtime we have to pay, what kind of records we have to keep, what we need to do when we terminate an employee. All of those laws differ, and many more. Occupational health and safety requirements differ across provinces. Pay equity considerations differ as well. Now, things like occupational health and safety, the differences can be quite significant in terms of things like whether the employer needs to actually somehow inspect the home workplace to make sure it's safe. There's specific requirements in some provinces and less specific requirements in others. So all that to say that as you increase your flexibility, which you may want to do for recruitment purposes, which your employees may be interested in, it's important to keep in mind that adds complexity to your considerations that you want to make sure you can deal with up front before offering that type of flexibility. As we go out of country, there's also things like tax considerations, immigration-related considerations, and again, employment standards, occupational health and safety, all those laws that differ between provinces, well, they can differ quite significantly between nations as well. So again, flexibility is likely something that you're going to want to offer, but at the same time, you want to balance that against what level of complexity are you ready to take on, and probably engage with a conversation with your legal counsel to see what that complexity looks like and what it would look like to address it. That's something that doing it out front can help you get in front of these issues and determine what makes sense for you in terms of your hybrid workplace. Another important consideration, discrimination risk, human rights risk. We want to be mindful of these issues as this slide illustrates throughout the different stages of employment. So general point here, employees have a right to be free from discrimination and harassment in the workplace. That applies throughout Canada. The human rights codes are a little different from province to province in terms of what things like the protected grounds are in particular, but this basic principle holds. And thinking about our hybrid workplace, we want to think about how we're doing each of these things differently. Right? So how are we attracting our employees? Right? How are we selling the workplace to them? And then through the application and the onboarding process, how are we getting to know what potential employees as candidates will offer? How are we welcoming them to the workplace? Then how are we retaining them, developing that talent, managing an exit? And those can be sensitive conversations, obviously, where you want legal counsel involved in terms of a severance or a resignation. And we want to, ideally, if we can, and it's more and more of a trend among employers now, to get to an alumni stage where our former employees become effectively promoters for our workplace. Right, so you have a way of doing this already in your workplace, and you're probably mindful of your human rights obligations. In moving to the hybrid workplace, you want to, again, keep in mind the potential for systematic discrimination, systematic exclusion at any of these stages, and make sure you're addressing that out front. And keep in mind, discrimination, we know the traditional grounds that come up a lot are things like disability, working with employees with doctor's notes, but other grounds of discrimination include marital status. They include family status, being in a parent-child relationship. So if someone has caregiving duties for an elder parent or for a young child. And at the recruiting stage, we want to consider, well, are we ensuring that that person feels welcome to apply to a job here? Are we excluding that person on the basis of some protected grounds, some circumstance in their life? And that could lead to potential liability at even the recruitment stage. It can certainly lead to potential liability at the stage of when the individual is actually working. So when we change to hybrid, we want to make sure that we're not changing the game in a way that systematically excludes employees, discriminates against employees on the basis of a protected ground. I want to remember that human rights looks at a number of things, but it looks at both explicit, overt discrimination, where we just exclude a certain group of people and say you're not eligible to apply, but also there's an implicit constructive kind of discrimination, where on the face of things, we're not intending to discriminate against a group, but in effect, the policy ends up doing that. Right? So we want to be mindful of not only what our policies say, but what they end up doing. And so human rights, a very important aspect of compliance. And whenever you make a workplace change, you want to have at least some sense of how that may be affecting different groups and stay ahead of that issue as well. So that's managing compliance in a nutshell. And again, I don't want to get too much into the weeds of different compliance requirements across provinces, but I think those are the key points that employers should keep in mind. And obviously, if you're looking for more details, that's something that I and my colleagues or your legal counsel can assist with. But I want to get into moving on to the next stage then, so managing performance. Right. So now we want to think about, we've thought about sustainability and compliance. Now we want to think about being effective and being competitive. How do we make sure that we get the most and the best and avoid getting the worst outcome from our employees and our employee teams? And I do apologize for my slides jumping a little bit with a mind of their own. So you're going to consistently see me going forward and then backing one up. So I apologize for the little hiccup. So here on this slide, we see some examples of individual level, group level employee challenges that we've historically seen in remote workplaces, which we've worked with before the pandemic, and that we expect to see in hybrid workplaces in familiar ways and in new ways moving forward. So things like overstated time on task, you're not at the office, so your employee tracking of hours can become more loose. So we want to make sure we address that. Things like work product plagiarism, work product outsourcing, and I've seen this in a number of cases where we want to make sure that employees are actually doing the work. This can be a risk at any workplace, but I think it becomes particularly so with remote workers just because you're not in the immediate workplace. We've seen examples of clients, for example, whose employees were submitting great work. However, the employees weren't the actual ones doing the work. They had hired a third party, sort of contracted out the work to a company overseas where someone else was doing the work for them, which among other things gave rise to significant confidentiality concerns. You have issues of poor team synchronization, perceptions of fairness among team members. When you have in a sales type context, inaccurate recording of sales or sales leads, communication breakdowns, challenges with institutional memory. And a lot of these come down to, again, people not being in the same place at the same time necessarily, that lack of synchronicity, that lack of transparency that comes from that. People aren't necessarily aware of what their colleagues are doing, of what their managers are doing. Managers are not necessarily aware of what employees are doing. So transparency, visibility, shared space, and synchronicity, when we lose these things, these issues can arise or become augmented if they already existed in a workplace. So communication and shared spaces, again, are going to be key to some of the recommendations that we're going to be going through in the next couple of slides. And we also want to highlight on the other end, so there's challenges to performance. And then when we want to come to employees and performance manage them, provide them coaching, guidance, direction, similar challenges can again arise from communication breakdowns due to technologies, inconsistent touch points. So for example, if you have employees who are in different time zones from their managers, this can be particularly an issue of just basic touch points to connect and consistency of communication. Again, perceived unfairness between employees, perceived breaches in the psychological contract. A lot of this comes down to, once again, asynchronicity. Employees not being in the same time and place and in a shared space with each other. They don't see what their colleagues are doing. They don't see how much work their colleagues are doing, how much work they're doing relative to their colleagues, or what type of opportunities everyone's getting. And when you lack that transparency, and lack the consistent touch points, shared meetings, and shared space for people to get on the same page, to build some institutional memory, to build a sense of team and teamwork, and then balance and harmony between team members, you can have that strain to the psychological contract, right? Again, people's reality might not be meeting their expectations, or they might perceive that that's the case, and those perceptions can sort of build and can fester over time. And so you want to be mindful of those touch points. You want to be mindful of these sort of breakages and leakages in communication where there's perceived lack of transparency and what can grow in place of transparency and shared space and shared communications. Right? And this is, it's not strictly a legal issue, but again, these become legal issues in the way that I talked about in the earlier slide. That when you have employees who have a perception of a breach in their psychological contract, from that can arise performance issues, security issues, more inclination to be litigious when problems at the workplace arise rather than approaching management. So that's one of the interesting things about my job is I will advise on legal issues and walk employers through legal complications. But the way we usually get into those issues and the way we usually get out of them depends a lot on these interpersonal aspects, the people management aspects of the workplace. So I see the two as intertwined. I think it's important to address both together when it comes to things like thinking about the hybrid workplace and how we manage that. Okay, so here's some suggested measures for mitigating some of these pitfalls, some of these risks in the hybrid workplace. Again, maybe a useful slide if you're reviewing to stop on, pause the video here and review some of these, see what might be useful to you and what might particularly apply to your workplace. I won't spend too much time on them, but just reviewing some of the key ones, starting with the very top. Survey employee expectations. Can't emphasize this enough, and this is something that KPMG certainly assists with in a number of contexts. But the point here is, if you want to know where your employees are at, what they're looking for, what their expectations are, and there's particular ways to do this, but a good principle to start with is just ask. Right? See what your employees are looking for, what their expectations are, what the possible pressure points are in the relationship. There's ways to ask those questions and there are ways to learn that rather than necessarily guessing. So depending on what your situation is, definitely approach that you might consider starting with. Right. A lot of activities here also talking about visibility, team building, transparency and accountability frameworks, right? Build in policies where we're thinking about how do employees connect, consistently communicate, and maintain visibility to one another and management. We can think about things like core hours, core days, right? Sort of days where everyone is required to be in some shared space. So core hours for being online, for instance. Everybody's online at certain times. They know if there's a question, they can reach out to their managers, their colleagues. They can get into a virtual room together and collaborate, the sort of thing that you would get at the office that you can miss in an online remote type setting. And then also making the most of your office space in the same way. So rather than having people sporadically come into the office when it's convenient for them, but they still might never see each other, think about having core days or periods of time where everybody needs to be at the office, or certain groups of people, certain teams need to be at the office together. Again, not necessarily because something is planned for that time, but just trying to make the most of that space, that you can have those bump into each other conversations and collaborations, and again, an opportunity to communicate, to maintain transparency and connection, culture, shared space, and institutional memory. These are all important for a collegial workplace where individuals, again, when issues come up, they feel comfortable coming to one another and coming to management, and that can mitigate and alleviate a surprising amount of legal issues down the line if you have those, let's call them cushions in place that address some of those issues of the psychological contract. You have at the bottom too some notes about establish clear policies and expectations regarding things like call-ins, when an employee is required to be at the office. If you suspect that outsourcing and plagiarism may be an issue at the workplace, maybe develop a policy around that. And all that to say, that's where you probably want to contact your legal counsel, contact KPMG. And we have policy templates that we work with. We can make something tailor-made to you that addresses your workplace concerns, and again, gives you those formal structures, those legally enforceable structures, and that may be a policy, that may be an employment contract, or a combination of both, and gives you the tools to legally reinforce and enforce certain expectations and requirements in the employment relationship. And the last thing I want to talk about is to get back to a more legal topic in all of this. We want to think about not only where we get to in terms of the hybrid workplace, but how we get there in terms of managing the process and managing change. So again, I'll try not to spend too much time on this, but it's important when you're making a change in the workplace, and it's one of the first things your lawyer will tell you, or you might come to your lawyer about when you're changing something at the workplace, is this constructive dismissal risk. So again, good slide to pause on. This is the legal test essentially for what makes a constructive dismissal. It's when an employer unilaterally, so we decide to make a change, and it's a substantial change, and it's a change to the essential terms of an employee's employment agreement. We'll go over what some of those things may look like, but essentially we're making the change, we're doing it ourselves, it's a big change, or it's considered that from a legal perspective. It can be to the express terms or the implicit terms of employment. And then the employee has to turn around and say, no, I don't accept that change, and then resign within a reasonable period of time, this sort of legal fuzzy term that refers generally to, not too long after the change, but it's not a specific period of time. All right, so important to keep in mind that there's the change aspect of this. We have to make the change as the employer, but then the employee has to turn around and say, no, they reject the change. So an important piece of mitigating constructive dismissal risk is, well, if the employee agrees, if they consent to a change, then the constructive dismissal test is not met. In other words, there's no dismissal if we have employees on board, right? So again, this interpersonal psychological contract piece, we can see again, is important to managing the actual legal risk that we come out of this with. So examples of risk points in the transition to hybrid. For example, you've had employees working exclusively remotely from home. Now we require them to come to work some of the time, or even a lot of the time. That's effectively now changing an established work location. So that can be an issue. Or being required to travel from work to different locations, especially if the employee has moved pretty far out from an office location. And now we're requiring them to travel a significant difference. That can be a significant change. Differences in compensation, benefits, advancement opportunities. So if explicitly or implicitly you get more benefits, you get paid more, you get more opportunities if you attend the office more, there's a potential issue there in terms of an employee saying, well, you've changed my compensation, and that's a constructive dismissal. We like to use this word constructive a lot. You see constructive changes to compensation. So that basically refers to, again, just like constructive dismissal means we've terminated someone at law without actually intending to do so, we can also end up changing legally someone's compensation without intending to do so. So again, examples of this are something like if we offer a gym benefit, a paid gym benefit, but you have to be at the office to take advantage of it because the gym is right next to the office. So your remote workers have lost that benefit, have lost that compensation, right? That's an example of that sort of thing, right? So that's an implicit change, a constructive change that, again, puts us into this area of risk. Changes to reporting requirements or supervision structure. Again, constructive dismissal looks at sort of the package of changes. So it may be that any one of these changes, if we make them, could be not very significant. But if we're transitioning to hybrid and a lot of different things are changing at the same time, then again, that package of changes all within a short time of each other, if that all amounts to something significant, can again bring us into this area of constructive dismissal risk. So that's where a good idea to reach out to your legal counsel if you're changing things around and you want to know if you're entering a sort of risk area, and your legal counsel can advise you on some mitigation strategies. But right off the bat, you want to be thinking about, okay, if you're making a change, survey your employees, assess their expectations. Think about whether you're creating 2 or more classes of employees. And then point number 3 on this slide, think particularly about your high-risk employees. So a lawyer can tell you exactly who these are, but they tend to be, in a nutshell, employees with more seniority, employees who make more, employees in managerial positions or close to retirement age. Those employees, for various legal reasons, would stand to gain more from claiming constructive dismissal. There'd be more on the table for them to receive in terms of a severance payment if they were to make a claim that they've been constructively dismissed. So good to talk to your legal counsel to see who those people are. If you have a lot of those people in your workplace, then again, you might want to take particular care, pay particular attention to those individuals. Think about getting written consent. Right? Think about how to get employees to agree. And you might want to provide some form of extra payment, some other form of incentive in order to get them to sign on the dotted line, even amend their contract. And then the final point here, and an important one, provide as much notice as possible. So when we're making a change in the workplace, it's one thing if we announce the change is happening next week, and then we have a bunch of employees come to us and say, well, I'm going to resign or I reject the change. That can leave us with a significant legal risk on our hands. But think about another situation where, okay, same change, except we announce to employees, we're making this change in 12 months. Now when those same employees come to us and say, well, we don't accept the change, we're going to resign, then we can turn around and say, well, the change is not coming into effect for another 12 months. So, there's no change to resign about for now. You can stay and work for 12 months, and that's your working notice period. All right, so again, various strategies you can use, and depending on your situation, when you foresee a change coming, and you foresee that this might be a significant change, there may be some issues, there may be some high-risk employees in the workplace, that's, again, a good time to get ahead of it, reach out to your legal counsel, consult, and determine what strategy, maybe using a combination of these strategies or others, would work in your workplace, would work in the context of your formal structures, your policies and your contracts, and also those informal structures in terms of your employee relationships, their expectations, and designing a strategy that works in that context to help you transition over to your hybrid workplace in a way that is, again, from a legal perspective, mitigating your risk and ensuring that you can that the changes you make, that the change itself is smooth, and that the resulting workplace that you transition into is, again, a sustainable one, which we want to help you succeed in doing. And that brings me to my thank you slide. So thank you for this opportunity. I'm sure there's a few questions, so I know I'll stick around and we'll see if we can get some questions answered. And of course, we're available offline as well, and and my email, I think, will be distributed. But yeah, I'm happy to answer any questions that anyone in the audience might have.
Fabulous. Well, thank you so much. I'm just monitoring the chat. If anyone would like, they can enter their chat into, or their question into the chat, or if you prefer, you can just simply unmute yourself and ask your question. We still got a couple minutes, so actually we've got about 15 minutes for questions, so that's perfect.
I just have a question. I'm not sure we can answer it, but what's an ideal balance for hybrid? I'm investigating a thing called the Great Resignation, and it's worth looking up. A lot of people are threatening to quit if they're forced to go back to work, and hybrid workplace is a solution. But what's ideal? Any idea? Half and half?
It's a great question, and I think ultimately the lawyerly answer, but I think the correct answer from this level of kind of what's right for everyone is it depends. It really depends on your employees and the nature of your workplace, and how your teams work together, and whether you have sort of one big team or several small teams that may have different preferences. I know at my workplace, like it's a large workplace. KPMG obviously has a number of employees, but the team I work with is, we're about 20 people. So we can be quite collaborative together, and I think for us, a 50-50 balance works because you want that, you want that sense of collegiality and collaboration, and the work really benefits from that. Whereas I think maybe if you have a group of more independent workers, people who tend to work best in silos, and maybe a shared space or physical space may be a bit of a distraction, or people have a lot of family obligations, then maybe it's more remote and far less at the workplace. So I think the key place to start is, again, at that point on the one slide where it said, just ask, right? Survey your employees. That tends to be when we work with our business consulting wing, when we get into workplaces, and we've been helping a lot of workplaces transition to hybrid. The first thing we do is carry out a pretty thorough survey of employees, get a sense of some of the things that I just described, like what are the teams like, how do people work together, what are their home situations like, and where are they now? Are they far from the office? Are they close to the office? What's feasible and what's desirable and what's productive with respect to all those variables, and you sort of go from there. I mean, 50-50 is probably not bad in terms of an assumption, and you can do a bit of trial and error and sort of set out an expectation and see what you get back from your employees, whether people are generally happy or express some discontent, and sort of tweak it from there, or you can try to survey at the outset and plan based on the information you get back. There's sort of advantages and disadvantages to both. So I could probably go on for a while, but that's, I think, the two key starting points.
Thank you.
Great question. Thank you, Dave. Oh,
sorry, Jessica. A question around the constructive dismissal piece. Would you have an example of what a substantial change would be?
Sure. I think the typical example and the most straightforward one is when it comes to compensation, right? So if we have a reduction in compensation, that's when we get into 10% reduction in compensation, we're in a risk area. And when we get into 15% and 20%, that's when we're in a pretty significant risk area. So usually when it's 20%, a court will say that's substantial. When it's 15%, it could go either way. And when it's 10%, then chances are you're fine, but there's still a risk. So that's sort of what you're looking at in terms of when you're changing compensation. And that can be not only salary, but that could be if you're reducing someone's shifts, if you lay someone off and the contract doesn't say you can lay them off, that would certainly be a big risk. If you're reducing or eliminating benefits and the person is using their benefits, that could be a significant risk. When it comes to other changes that are less compensation based, like a change in location or supervisor or job title, sometimes courts will take into consideration, they'll take into consideration the inconvenience to the employee when it comes to something like location. but they'll also take into consideration the employee's dignity and reputation. That might be a consideration. So if a change looks like it's a demotion and can be perceived as embarrassing to the employee, then you have a constructive dismissal risk there. And you have a bigger constructive dismissal risk in some ways if the change is perceived to be embarrassing, because then even if the change is 12 months out, the employee can say, well, look, everyone knows you're making this change and it's embarrassing. So, I actually can't come into work anymore because, that embarrassment has already happened. So I'm resigning effective today, and I'm going to claim that you terminated me as of today. And there's a chance they could succeed in that. So, again, the magnitude of the change, that 15 to 20%, that's a big threshold to keep in mind. And the embarrassment and reputation piece is another important piece to keep in mind.
Thank you. Very informative. Thank you very much.
Last chance for questions, anybody? Okay, and I will say, I know this session is being recorded, so if there's anyone that wants to ask a question that isn't recorded, you can always send me an email and we'd be happy to pass that along. So don't forget that that's an option as well. Alrighty, well, I think that's all that we have for today. Thank you so much, Maja, for that presentation. It was absolutely fantastic and very informative, so we really appreciate it. And to everyone for joining us today, thank you. We hope to see you guys again. Our next webinar will be on Thursday, October 14th for a ministerial roundtable with Nina Tangri, who's the Associate Minister of Small Business and Red Tape Reduction. Well, thank you, everyone, and enjoy the rest of your day.